I'm Jeff Newby, partner with Weber Gallagher from the Mount Laurel, New Jersey office. This is my partner, Mark Sotaro. He's also with me in Mount Laurel in the office next door, so we can brainstorm without even getting out of our chair.
Hello, everyone.
This is the second installment of the New Jersey webinar series. And at the end of the presentation, we're going to show you the future calendar events that we have in New Jersey, Pennsylvania, and Delaware. During the course of the presentation, if you have any questions, you can send questions to questions@wglaw.com, or you can email both Mark and I directly. You'll see our email address right on the first slide, and we'll get back to you before the end of business today. So what we wanted to talk about today is it's a different topic. It's a little unique, not legally related, not case law or statutory driven, but our topic is, why does New Jersey workers' compensation move so slowly, and what can we do about it? And the reason it's a topic is because it's a frequent refrain or issue or area of angst that we hear from our clients, and we've heard it over the years. And there are reasons for it, and we thought we would kind of flesh some of those out. And at the end, we're going to give you some suggestions on what, if anything, we can do to speed up the process. So, turning to the first topic, the first problem that you run into, the filing of the claim petition in New Jersey. Oftentimes, the New Jersey claim petition, when it's filed, there's no real dispute between the parties. That is not the case in other states. And I'm very familiar with Pennsylvania workers' compensation. For example, we can use that state right across the bridge, right across the border. I did Pennsylvania workers' compensation for over 20 years. And I can tell you the difference between the two is distinct. In Pennsylvania, when a claim petition is filed, a termination petition, suspension, or modification, the lines of demarcation, the dispute is already drawn. Everybody knows what the issue is. A petition is not filed until it's time to do some battle. So by the time the parties get to the first hearing in Pennsylvania, there are rules that are laid out because you need to proceed with the evidence in support of your petition. So the claimant has to testify, or the defendant's medical doctor, medical expert has to testify about a full recovery. So there are distinct time deadlines. What is so different when you compare this to New Jersey? Assuming that we're not dealing with a motion for medical and temporary benefits in New Jersey. Let's assume now that this claim petition is filed and you're paying temporary benefits, you're paying medical benefits. Oftentimes the questions that Mark and I will get when we get these kind of claims is, why did they file a claim petition? I'm taking care of the guy. He's going to the Rothman Institute. He's going to reconstructive orthopedics. He's seeing a terrific doctor. I'm paying him a weekly tax-free check. What's he got to complain about? Frankly, he doesn't have anything to complain about, or she doesn't initially. They're getting the benefits you're providing. What they want is that third benefit, permanency. Permanency is generally not available in Pennsylvania and other states. Permanency is not addressed until treatment has concluded. There's a built-in delay in many of the claim petitions filed in New Jersey. So depending upon the nature of the injury, there can be a significant delay before any real litigation, discovery, or resolution can even be attempted. As opposed to Pennsylvania, where the case is ready to move at the time the petition is filed itself. New Jersey may have months or years before actual litigation begins. And I say years, in the rare case where somebody has a significant back surgery, it fails, they have a subsequent back surgery, they need pain management, they have failed back syndrome, all with authorized physicians. From a defense counsel standpoint, we can help you, guide medical treatment, potential second opinions to make sure everything is proceeding as it should be. But in terms of litigation, what the judge needs to decide, assuming temp and medical are both being paid appropriately, there is nothing to litigate yet in New Jersey. That's quite unlike other states. So states such as Pennsylvania have strict time and deadlines. In fact, there are the special rules of practice and procedure, which I used to be quite familiar with when I did Pennsylvania, a lot more than I do now. They're very strict deadlines. From within 60 days of the first hearing, you need to have the claimant's deposition, the claimant's expert. Within 90 days, the defense has to proceed with their depositions, their experts. Some of the judges at the first hearing give a final hearing date 9, 10, 11 months later, and at that final hearing, they expect all evidence to be presented, the record to close, and briefs to be submitted. That is not the case in New Jersey because, again, the dispute has not yet been crystallized or finalized when the claim petition is filed in New Jersey. Now, what I call the cousin to the Pennsylvania claim petition in New Jersey is the motion for medical and temporary benefits, whether it's a straightforward motion or the emergent motion, which we thought that might be an issue or a problem for us. There's been very few emergent motions filed. Emergent motions move even more quickly than motions for med and temp. Those contested motions, they move much more similarly with speed with respect to or compared to the Pennsylvania claim. Because in the motion for med intemp, the petitioner is not receiving temporary disability benefits. They're not receiving medical care. Again, that's like a PA claim where the claim is denied. Those cases in New Jersey move promptly. At the first hearing, there should be a meaningful conference. There may be testimony from the petitioner at the first listing, which could be 30 days from the date the motion is filed. And if there is a true contest and nothing can be resolved, every 3 weeks there should be witnesses testifying until the judge renders the decision. So those do move quickly. Those are the closest corollary to a PA type of litigated claim petition. But in a claim petition setting only in New Jersey where they're just seeking permanency, that's going to be a lot slower. So Mark's going to talk to you about some of the other issues that can cause some delay in New Jersey.
As Jeff alluded to before about emergent motions, and I just want to highlight that, emergent motion is actually a fairly recent change to the statute where they allow emergent motions to be filed. But as Jeff had indicated, there are very few of those that actually get filed or allowed to be filed. They're very closely monitored. When they do get filed, a supervising judge will look at it and see if it meets the emergent criteria. If it doesn't, it goes on to a regular motion list. But again, as Jeff indicated, there is no reason to file a claim petition right away. But in New Jersey, that seems to be the way things work generally, and I think that's happened over the course of many years of doing workers' compensation. Attorneys tend to file claim petitions right away instead of waiting for an issue to arise. As the PowerPoint indicates, there is no waiting period for filing a claim petition. It can be filed as soon as when an accident happens and a petitioner comes into an attorney's office. All this is done online, so it can be done very rapidly by simply filling out a form online, and that claim petition gets filed. Oftentimes it's filed while benefits are still being provided. Medical care is being provided, temporary disability benefits are being provided. So there's nothing really to litigate with that claim petition other than to file an answer to it. The only limitation on filing a claim petition is the fact that it must be filed within 2 years after an accident occurs, if the accident itself is a contested matter, or 2 years after all medical treatment and all benefits have been provided under that claim. So if in an admitted claim situation where someone is getting treatment and temporary disability benefits and may be out of work for a year and receiving treatment, that claim petition doesn't have to be filed until 2 years after all that ends. So that's the statute of limitations for that. Why do the claim petitions get filed? They get filed early for the petitioner's attorney to have access to us, the defense counsel. This way, if any issues arise with the claim, perhaps treatment the petitioner doesn't like, or they're having issues with the doctor, or something is not getting paid or provided, they'll have access to us because we'll file the answer, and that opens up the line of communication. A claim petition is filed, as I said before, online. That's called the courts system, and it's the acronym that I put on the screen. That is, you have to register as an attorney, or an insurance carrier can register to have access to courts. That allows you to file claims. It allows you to have access to that claim. So when you file a claim petition, you have immediate access to the court system on that claim. And as the defense counsel, you have access to that claim as well as any other claim that that petitioner may have filed in the past. So you can do a little search to find out if they have any pre-existing conditions and so forth. Another reason why they could file it is that the fact that the claim petition is filed allows them to have access to the court itself, and if an motion needs to be filed, it's filed immediately. Again, that can be done online. It'll get listed right away. Again, it'll speed up the time for the case to be actually listed for court.
It's actually a shorter time frame for the answer to be filed. So if a claim petition's already been filed and then they file the motion for med intemp under the rules, we have 10 fewer days to file an answer,
right,
because they're already in the court system.
Right.
So
And I put this down here, use the court for a diary. I used to do petitioner's work, and I was guilty of this as well, where a petitioner's attorney will file the claim petition, and the case will come up in court after about 3 to 4 months after it's initially filed, and then it'll come up repeatedly after that as you tell the court what is needed to be done on the file. They'll adjourn the case. So therefore, it can be used as an attorney diary. If something needs to get done, it'll pop up on a court list. They'll know to look at their file and finally do something about it. And the other reason is to make sure that the petitioner's attorney secures their client. Once the claim petition is filed, signed off by the petitioner, that petitioner is the petitioner's client. So that secures their client. If they wanted to go elsewhere, they're certainly free to do that, but they have to file a substitution of attorney and so forth. So there's another step that the petitioner would have to do if they wanted to go get another attorney.
And the first attorney would probably have some kind of an argument for sharing counsel fees.
Correct.
Because we would like to see them file claim petitions perhaps after the person is discharged from care. But if they meet with their counsel and they're in the midst of treatment, and the attorney says, come back to me when you're discharged from care. It could be a couple weeks later, it could be a couple months later, it could be 6 months later. At that point, they may have met another attorney. And so as Mark says, securing the client, they want that client signed on the bottom line. If they have them in their office and they're interviewing them about a comp injury, before they leave, they want a signed claim petition so that they do have that client locked in. So that's one of the reasons why they do it, and sometimes they do it, as you see all the time, within days of an injury when everything's already been taken care of and you've already addressed the case and are providing benefits. So the next topic I want to talk about along these lines is what's good for the goose. And what I mean by that is the double-edged sword of the New Jersey meandering process of litigation. It goes both ways. It strikes to our detriment in terms of the files move too slowly. So we have brokers and agents and actuarial tables that are hanging out there with reserves that you want off your books. On the other hand, the benefits of New Jersey are, there's a number of them, and here's a few. Answer to claim petitions under the statute are due within 30 days of the date of filing. And Mark and I have probably the same answer. We can do it simultaneously. How many cases have we had a motion to default filed, a motion to default granted, and a motion to default never lifted by a phone call from defense counsel like us?
Zero.
That would be zero. We've never gotten a default judgment against us. We've gotten files sent to us with the default judgment on top of the file, and a phone call later, the motion for default is lifted, which is great. That's nice. That's not the case across the bridge. Again, Mark doesn't have the PA workers' comp background, but I do. And yellow freight is like a two-word curse phrase in Pennsylvania. If you don't file an answer within 20 days of the assignment of the case to a judge, all well-pled allegations are admitted. That is dangerous. In New Jersey, that is not the case. We get phone calls from chambers occasionally, from a judge and a petitioner's attorney saying, hey, Mark, don't you represent this employer? We've seen you in court before with this employer. This is the third listing of this hearing. You guys going to file an answer? We don't even know anything about the case. We'll make some phone calls. We'll get the claim. We'll get an answer. We'll discuss the case by phone with the parties there and start getting the ball rolling. So it's a very laid-back process. So some of you may not want to hear that, but it inures to your benefit in terms of they're not going to be taking snap judgments against you, with the exception of the motion practice, motion for med intent, and the emergent motion. Those need to be answered, or the judge will sign an order against you. So, again, late answers do not preclude defenses to all the issues in the case. The motions for default are routinely withdrawn, and if there's a motion for default granted, which is also really rare, they'll lift that with a phone call. So another thing to keep in mind in terms of the advantages of New Jersey versus Pennsylvania, there's no interest on past due awards. So if there's a delay in the case with discovery of getting medical records, we find out that they treated with a chiropractor 2 or 3 years ago or a decade ago, and we want to see if the chiropractor perhaps sent them for any kind of studies, because we want to determine whether or not that bad back pre-existed. It may not be a defense, but you may be entitled to a credit off of the permanency award. So we've got to go get those records. The time it takes for us to get those records, there is no interest calculator running. The award and the dollar figures are going to be the same. If it's a 2014 claim and it's settled in 2015, 16, or 17, the dollar figure attributable to that 2014 claim is going to be the same dollar figure. And for those of you who have other states' backgrounds, like Pennsylvania, simple and accrued interest increases the awards dramatically. And we've had, the back due temp awarded by the judge, it might be $25,000 or $30,000. When you add the interest, it might be another $7,000, $8,000, $9,000 on top. So it gets pretty expensive, and that's not really the case in New Jersey at all. Very rare that you'll ever see penalties raised, and they're limited by the statute. And counsel fees are not seen as a penalty. They're seen as a sharing between respondent and the petitioner. Let me see. In terms of penalties for late payment, Mark and I were discussing this the other day. I mean, there is a time deadline in the statute for paying temp when the employer is aware of the claim and compensability and the person's out of work for more than 7 days. They're supposed to receive benefits within 28 days. We've never seen a motion to enforce or for penalties for failure to pay within 28 days. It just doesn't happen. Every claim you'll see in some other states will be accompanied by a penalty petition where the attorney is seeking up to 50% penalties.
Or in some states have automatic penalties that the carrier has to pay if they're late with a temporary disability payment and so forth. In New Jersey, they have to petition the court to get a penalty.
That's true. And again, they're very rare. So anyway, let's move on to our next topic. And it's a process. Mark is going to take us through the litigating the claim petition in New Jersey.
All right. Well, so what happens after the claim petition is filed? Well, if a person is treating, they're getting benefits, everything's being taken care of, they're under active medical care, they're receiving temporary disability benefits, there really isn't anything to do. From an investigation side, if there's any evidence of pre-existing conditions, we would be sending for records of any or any information that we have, getting records of any pre-existing conditions. If they have a prior claim with the filed in the workers' compensation court, we will get those records. So basically what is happening is nothing as far as the court is concerned until a person is discharged from all treatment. As they're treating, we will gather medical records. Once they're done treating, we'll make sure we have all the medical records from the authorized doctors. Again, we'll send for any pre-existing condition records or anything like that. After the person is done treating, they return to work or may have not returned to work, but they are done treating, and there's the next step would be to make sure, again, you have all the medical records, and you will be setting up a medical evaluation. The evaluation is intended to render an opinion from our side as to what the permanent disability is as a result of this work injury. The petitioner's attorney does the same thing. It is our obligation to provide the medical records for authorized medical care to the petitioner's counsel. So we try to get those out as soon as we get them. We'll send them out to the petitioner's attorney. There is a rule that allows the respondent counsel to wait 26 weeks after the end of treatment to set up an evaluation. That is sometimes exercised. We do it sometimes if it's a really bad injury where you want to make sure that they are fully healed from the treatment that they were receiving, and you don't want to have the person evaluated right when they're done treating when pain is still great and they may still be feeling the ill effects of the injury. You'd rather give them time to heal a little bit more, and this way when they're evaluated they may have less complaints. Maybe there's less of a disability by the time they're evaluated. So that's why you would wait 26 weeks.
And scarring cases. We always recommend in a scarring case you should wait probably a full year before they're assessed. If they have to be assessed at all by an expert, sometimes we can settle those with the judge viewing the scar. But other than that, you want 52 weeks to go by from the date of the event to allow for a full healing of the scar. You don't want an award based upon something that is not fully healed yet.
Right. I point out here that the respondent experts maybe are generally more available. We both have experts on either side that we regularly use. For petitioners, they have to pay for their evaluations. The petitioner sometimes has to pay out of their pocket. Some petitioners' attorney have a practice where they'll pay for it and they'll get reimbursement at the end of the case. And some doctors on petitioner side will hold off on receiving payment until the case is settled, and they'll accept it out of whatever the settlement is. But right then and there's a built-in somewhat delay in getting their exam done. We don't have that problem on our side. We set up an evaluation, it's done. There is a cost limit on a petitioner's exam. They're entitled to be reimbursed up to $600 for their examination. At the time of settlement with an award of compensation, the cost of that exam is split between the respondent and petitioner. So the respondent winds up paying for half of that, but again, that's done when the case is concluded. Again, there may be a built-in delay in getting the petitioner's exam scheduled. Their doctors tend to be a little slower than ours getting their reports done. Some doctors work with the way they practice in scheduling their exam is that they have the petitioner actually contacting the doctor to schedule the exam. So the attorney for the petitioner lets their client know, here is the doctor, contact the doctor and set up the appointment. That's the way they operate. Where we set up the appointment, get it done, send out notices to everyone, and it's done in very expedited fashion.
So I think, the next slide that we're talking about is one that I threw in there. And when Mark and I were talking about it, he was kind of curious what I meant by what can be done about it. And what I mean is the slow movement of the petitioner's examinations, the slow preparation of the report, especially by some of the North Jersey medical facilities. And it's really up to the judges. The judges need to put pressure on the petitioner's bar to move these cases forward more promptly. We can file all the motions to dismiss we want, and we will do that. We'll file the motion, we'll get it in front of get the judge's attention, make our arguments in court that the file's moving too slowly, they haven't scheduled their exam promptly, etc. But if it's the petitioner's attorney's mistake or delay, the judge is far less likely to do anything detrimental to the claim petition or consider dismissing the claim petition, because the petitioner themselves has not made a mistake. They walked into an attorney's office, maybe the first claim they've ever filed, first injury they've ever had, and the judge isn't going to dismiss their case because they chose the wrong attorney. Because what do they know? So their attorney may be slovenly, may be disorganized, may not be scheduling the examination promptly. Their expert may have seen them. It may take them 2 or 3 months to get a report. That sounds ridiculous because the defense expert reports are generally available within 2 weeks, maybe 3. Some of the other experts on the other side of the fence are months out, and that is very frustrating. And we will file those motions, but oftentimes the judge is going to put those aside until the petitioner is the one that fails to cooperate.
Right. And as you indicated, you use the judge. The judge is the one who's going to be the driving force usually in getting things moving along. Obviously, judges are different. Some are a little more forceful than others. But when you show them that we're ready to proceed, and that the other side may be dragging their feet, they will take action generally to say, okay, have you scheduled your exam yet? What is the date of your exam? What doctor are you using? That puts a little pressure on the other side to get things moving along.
Yeah, and not all the judges do that. And the judges that do that insist on the examination date before they adjourn or continue the case once all treatment is concluded and records have been exchanged between the parties. We appreciate it when the judges want that exam date. And from our standpoint, our firm, when we go to the hearing and everything's been completed, treatment's over, we give exam dates. We're not going to adjourn the case and not give an exam date. Well, and if you guys are scheduling it, you being the adjusters, TPAs, the employer, we'll ask you to get us that exam date. And if you want us to, we'll get the date and give it to the judge so the judge knows how far out to move the case. And we're also going to want that exam date from petitioner's counsel as well. Hopefully the judge will back us up on that. The next thing I wanted to talk about is, I guess the difference between both sides of the bar. On the respondent's counsel side, on defense counsel, we're generally prompt in gathering, discovery, and scheduling examinations, and that's what we do for a living. We're set up with staff and computer systems that diary our cases and follow up, and we have clients like you guys who email us and say, have you done this? And you follow up with us, and that you'll be sometimes our diary, unfortunately, but it's a good thing. As a team, we'll move this file forward. But the other side, sometimes that can be problematic. We get sometimes limited cooperation from the other side in terms of getting us signed authorizations. The authorization process, if we have to go that route to get records, can be extremely slow. And we try and avoid that if we can do it. What happens is we'll look at a file and realize we need either family doctor records, chiropractic records. heaven forbid, authorized records, which you guys should have, we need to send an authorization to counsel to get that MRI or that opera report. We're not going to slow down a case for something silly like maybe some PT records. We want them, but we're not going to slow the case down for that. But if we have to sign an authorization or send one, we send it to the attorney who sends it to his client, who signs it, sends it back to his attorney, who sends it to us. We send it to the provider, who then looks at it and sends us a letter telling us how much they're going to charge us for copying. We then send them a check, then we get the records. That process can be weeks or months. So if it's in an authorized case, I may be jumping ahead a little bit on the PowerPoints, but if in a claim where the treatment has been authorized and they're your doctors, we hope we never have to do that. So please gather all the medical records for us. So Mark is going to talk about how to about expedited closures and some of the limitations we have in moving forward on those cases. Whoops, where are we?
That's it.
There we go. So these are you're going to talk about some expedited settlements and Section 20s.
Okay. Well, as we talked about before, usually the issue in a claim is the nature and extent of any permanent disability, and we talked about that before. You have the individual evaluated by both doctors on both sides. These doctors will give opinions as to what the percentage of disability is, and then we go to court. It's usually conference with the judge. Sometimes we'll get an opinion from the judge. Sometimes we'll be able to work things out between us. If the petitioner is working at the time that they've completed treatment and been evaluated, there isn't really any urgency to get things done sometimes in that regard, other than to get some money in their pocket. But you know, it'll move along at a normal pace when there are no real issues involved as far as permanency and getting to that point. The one way to close a claim is, as the PowerPoint indicates, is a Section 20 settlement. A Section 20 settlement is intended for claims where there is a dispute. There's a dispute as to liability. There's a dispute as to whether the accident arose out of it in the course of one's employment. There's a dispute as to whether the injury that petitioner, the individual is alleging, is related to this incident. So there are all kinds of issues that could give rise to a Section 20 resolution of a claim. What a Section 20 is a cash settlement. It's not an admission of liability. It's basically just what it implies, a settlement, but it's a settlement with prejudice, meaning that if you resolve a claim by way of Section 20, the claim is done and the petitioner can never reopen that claim, which is different than a regular settlement with an award of compensation. An individual can reopen that claim within 2 years after they receive the benefits from that award. So again, with a Section 20, there must be an issue. There must be a legal issue, their basis for doing this. If the only issue is whether or not there's permanency involved, where you have an admitted claim, where medical treatment has been provided, maybe they received some temporary disability, maybe minimal treatment, but it was an admitted claim. The only issue being whether or not that injury is permanent in nature. There's objective evidence of permanency. You can resolve a claim by way of Section 20 on that grounds. It's a little more difficult. You're going to have an evaluation from the respondent doctor, at least, that says there is no disability here. And the judge is going to have to buy it as well, because the judge ultimately has to prove it. The other important thing to note about a Section 20 is an individual has to be represented by counsel in order to get the approval by the court of a Section 20 settlement. You can't go in with an unsuspecting petitioner who doesn't have an attorney and is trying to litigate their claim themselves. It's a Section 20 claim. It is not permissible. It won't be put through by a judge. So that's important.
And as you mentioned, it has to be approved by a judge, so it has to be in court. Right. Other states may allow stipulations being mailed around and signed and filed with the court.
Right.
New Jersey's got to be done in court.
Every settlement in court.
And with petitioner represented by counsel. So there's definitely limitations. And I know a lot of our clients, and understandably, want to move these cases quickly, get a Section 20 settlement because it's full and final, but there are significant limitations right in the statute. And we get as many Section 20s, if not more, than anybody does, because we really push for them hard. and you have to look at them sometimes a little bit outside the box. Sometimes temp and med are being paid, and Mark will give some examples here, where maybe we did pay some temp and med, but we're still able to get a Section 20. Here's some of the examples. You already referred to the zero.
Yeah, the zero, or like Jeff said before, you have a minor scar injury. It's an admitted claim. Maybe they had a little laceration, a little scar. There's no real physical limitation from a scar. So generally those can be resolved by way of Section 20 because it's not something where it's going to get worse and the individual is going to have to come back to court for any treatment in the future versus an injury like that. Obviously, if it's a deep laceration, nerve damage, we're talking about something else, then there will be permanency involved. Again, this requires, the cooperation of everyone. You have to have a petitioner's attorney who may be reasonable to deal with, who's willing to at least recommend a Section 20 to their client, and a judge who will be in a position to approve it. The judge is going to want to make sure it's a reasonable settlement, that there's a basis for the settlement, that there are legitimate issues involving the claim of either compensability, liability, or again, permanency.
And as Mark is pointing out, we need everybody on the same page, and it does vary. It varies drastically from attorney to attorney, who's more aggressive in demanding that the case have future rights to reopen, which judge is more of a stickler for the medical evidence, the facts, and the law, and won't approve a Section 20 under certain circumstances, or won't approve a Section 20 on an expedited basis without both sides, or at least the petitioner's attorney, getting an expert evaluation. Some judges are totally lax about that, or relaxed. We'd say relaxed, but we wouldn't say lax. We like it when they do this. They see two attorneys representing each party. They say, you guys got a Section 20, I'll approve it. Other judges will not do it. They look beyond the attorneys, and they look to the injured worker, and they feel as though they are the kind of backup attorney, because they know us as respondents counsel, we want the Section 20. Petitioners counsel, they may know them well enough to know that they just want their 20% of the Section 20. They want to make sure that the petitioner is not being taken advantage of. So they're going to want the basis for the Section 20 spread out either in chambers or on the record. And if they don't hear what they need to hear, they may not approve it. And we've had that happen a number of times where
Yes.
Section 20s have blown up. So the next topic I wanted to talk about are these adjournments are killing me. Adjournments, continuance, whatever adjective or word you want to use. And we understand why you hate hearing the word adjournment, and I want to talk about those just a little bit. The majority of the adjournments are generally requested by a petitioner's counsel. More often than not, they're requesting an adjournment because they need to get records that we're unaware of. They need to meet with their client to discuss a permanency offer that we've made to settle the case, things of that nature. Obviously, if they're under active medical treatment authorized by your physicians, again, then both parties will agree the adjournment is necessary because, as we mentioned at the outset, there's nothing yet to litigate. One of the more frustrating areas that I don't have in the PowerPoints necessarily is in the unauthorized treatment setting. So the claim's denied, they haven't filed a motion because they have another source of benefits. So they're receiving short-term or long-term disability benefits or some AFLAC policy, and they're getting medical coverage through a different source. So oftentimes they will get that treatment on their own, and it's quote-unquote unauthorized. We're not paying for it, so we can't control it. And the judge isn't going to tell the petitioner and petitioner's counsel, you're not allowed to treat with these unauthorized physicians. It's America. They can treat. So some of the more frustrating delays that I've had over the years are these unauthorized cases, and we have to push with the judge and counsel, sometimes file that motion to dismiss and say, we want to see the most recent records to confirm with whom they're treating, what type of unauthorized treatment they're getting. Even though it's not finished, we still want to get a handle on where are they. And maybe we'll set up an examination, a second opinion, to determine whether or not we can convince petitioner or petitioner's counsel, you're really wasting your time. You're really at a palliative level. Let's get to the issues of compensability, permanency, etc. But those are some frustrating scenarios with the unauthorized treatment. So the judges, like I said, most of the time the adjournments are made by petitioner's counsel on behalf of their client. And a delay in the case is usually not to the detriment of the respondent, because the petitioner is not going to get, as I mentioned before, any interest on their award. If we are asking for an adjournment in a case where the petitioner wants benefits, that's where the judge is going to look at it much more closely, especially in the setting of, let's say, a motion from an intent. We generally can't adjourn their motion. If they are out of work and not getting benefits, that case will proceed unless we have a really legitimate reason to get an adjournment. And oftentimes we'll get the agreement of petitioner's counsel because we've done something. We've set up that second exam to determine whether or not surgery is necessary, things of that nature. So we're going to talk briefly about the Medicare dilemma, and the next, I guess, area of delay that not just New Jersey but Pennsylvania, states, federal, and civil liability is facing.
Yeah, and as you may have experienced, Medicare has become a very big issue over the past several years, and it's being closely watched. But anytime Medicare is involved with an individual, it's going to cause a delay. If someone is a Medicare eligible individual, for whatever reason, if they're on Social Security disability or otherwise, there needs to be an investigation as to whether or not there are any conditional payments through Medicare that were made that are result of or related to the work injury. Recently, that regulation has changed. It used to be where the petitioner's attorney would have to report the workers' compensation claim to Medicare to find out if there are conditional payments. That burden has now shifted to the insurance carrier. When the insurance carrier has a claim, they're the ones, and they find out that there's Medicare, they're the ones that need to report to Medicare that there is a claim and find out if there are any conditional payments. And notice of any conditional payment lien is sent to the carrier. It's my understanding that the carriers have been getting up to date on this. They're setting up electronic systems where they're reporting these things immediately and getting quicker feedback. But the bottom line is it's got to be done. You can't put a settlement through until at least Medicare's interests are addressed. And if there are conditional payments, they need to be addressed. If there are any conditional payments that pop up on a lien that are not related to the work injury, but because of coding, the way doctors code bills and so forth, it's triggered to be a conditional payment lien, they have to be challenged. Those challenges now have to be done by the insurance carrier. It used to be that the petitioner's attorney, the petitioner had to do that. Now that, again, that burden has shifted to the carrier.
Which may speed things up.
Hopefully it will.
Because hopefully it will be faster.
But on the other end, we have the bureaucracy of Medicare, which takes forever. So this can also cause a delay. And it's gotten to the point where even workers' compensation has a designated marking on the court list where it's a Medicare case. And they'll mark it as such so the judges know that they may have to put off a case longer to complete an investigation. The section that is listed at the bottom here is I guess that was on the previous slide, is the regulatory section that was changed in October 15th or October 2015, where they changed that burden over to the insurance carrier. The other monster out there is Medicare Set Asides. Medicare Set Asides is different than the conditional payment. Medicare Set Aside is applicable when someone is on Medicare and you're trying to close out a claim, meaning that you're trying to Section 20 a claim. That's the only time a Medicare Set Aside is to be considered. There are certain criteria as to when you should consider a Medicare Set Aside. It's when a settlement is of a certain amount, or usually that's the triggers. If it's over $25,000 involved in benefits that have been paid or a settlement involved, that's generally what triggers the need to consider a Medicare Set Aside. Again, this is a very timely process. Insurance carriers have vendors that do this. We do them in-house here. We have an attorney who does that on a regular basis. They're very involved because you have to gather up-to-date medical records of all kinds of conditions that whatever the person is treating for. You have to get up-to-date medications from the pharmacy as to what they've been getting. All that stuff has to be given to Medicare with your proposal for a set-aside. If you're shooting for a $0 set-aside because you want to settle a claim and you don't feel it's necessary to set aside any money for potential future treatment because the claim is contested and there isn't any reason to set aside money for Medicare for use by that individual in the future, you have to have all your ducks in order to get that $0 Medicare set aside. So it's very difficult, time-consuming process. And again, after you file it, you have to wait for Medicare to respond. That can take months.
unless, as we say here at the bottom of the slide, unless the parties decide not to seek CMS approval, because CMS has told us you do not have to seek our approval. If you take our interests into consideration and you do so appropriately, then feel free. And if we don't like what you did, we'll come after you.
Right.
So
that's the problem.
Yes, that's the problem. The parties have to decide whether or not they're willing to take that chance. So we've talked about delays ad nauseum, and we apologize for that, but we needed to explain to you how the system works and how it's unique in New Jersey. So what are some of our recommendations on how to move these cases more promptly, or at least do the best that we can in our area? First thing we talk about is promptly gathering medical records. So no authorized medical bill should ever be paid without corresponding medical records. If you get a bill in without corresponding records, pick up the phone, call them, send them a quick email, fax, whatever, saying, got the bill, thank you very much. Can't consider it until you send me the corresponding records. All the records should be gathered and promptly sent to our office. If you know what I've seen more recently, and I've just kind of noticed, if you get a request for authorization for physical therapy, my plea to you is please respond to that promptly, especially if it's an authorized physician. There is no dispute. The quicker you get to them and say that physical therapy is authorized, the quicker the physical therapy is going to begin, the sooner they're going to get to discharge from care, that we can close the case, and we can avoid wasted phone calls, emails, etc. between our office and petitioner's counsel saying, my client's still waiting for the physical therapy to be authorized. I know you guys are busy just like we are as well, but the sooner you can give the okay to get physical therapy started, that'll speed the process along as well. And another request, many of you were terrific about this. When you send a new file to your counsel, if you could provide a quick but thorough summary of the case, the temporary disability benefits, the medical status, the medical records, a quick thumbnail sketch gives us a good idea of what we need to do to move the file forward for you and what may be missing that we need to go get for you. Okay, in terms of other ways or other areas, soft spots where we can move the cases a little bit faster, minor injuries. I think we're really good about this. When we get minor injuries, and I know I've had them and Mark's had them, these little cases come along. I almost hate to give you a budget when I do my initial status if I think my budget is more than the value of the case. But unfortunately, we don't work for free, so I have to give you a budget. So I look at these cases, and I see a minor finger case. And what I've done before, and Mark's done this, we call opposing counsel and say, are you kidding me? This guy fractured his pinky. It's worth, I've got probably enough lunch money in my pocket. And the response we'll get is, I understand the response is, I know this is a small case, Jeff, but it's not small to me because he's got 15 friends lined up behind him from this huge company that are going to give me the big cases. If I turn down this fractured pinky case, they're going to go across the street. So I got to take the case. So I say, all right, I understand that. Why don't we close it at the first hearing? Bring your client in. We'll let the judge look at the pinky. I'll talk to my client. I'll get authority in advance if I can. If not, I'll make sure they're available by phone. And we've been successful in closing cases at first hearings. And hopefully we can do it for just a few $100. So again, we try and do that for you in these minor cases. They used to be called informals. And unfortunately, most of them are now formal claim petitions filed by counsel. Again, we talked about minor scarring cases. We try and move those cases similarly to the fingers and toes. We reach out to opposing counsel all the time before hearings, looking for the report, looking for a demand. That's part of our mantra. When our report comes in from our expert, we immediately reach out to counsel and say, we're ready to proceed. Are you ready? And if not, what do you need to do to get ready? Sometimes we wish we could schedule their exams. Sometimes we wish we could drive their clients to the examinations, type the report, but they have to do their part and we do our part. But we do diary files for them and follow up with them frequently. Let's see, what are some of the other suggestions? The waiver of the 26-week rule. We recommend, except for as Mark talked about, more severe cases where we need the injury to kind of heal on its own. We recommend waiving the 26-week rule. And most of our clients don't want to invoke it. You guys want to close and move files. We gather medical records from you as soon as they come in and send them to counsel, petitioner's counsel, as soon as we can, as soon as they come in to get them ready to send their client out for their examination. Let's talk just a little bit about the uncooperative petitioner, and Mark's got some comments and suggestions on what we can do for the petitioners that are not cooperative.
Well, one thing I've learned over the course of the last several years is, we are all inundated with emails, but finally the petitioner's bar, I think, is getting caught up with email and email communication. first thing I look to on my adversary is, do they have an email address? Because communicating through them, sending notes, sending out evaluations, sending reports is, as you know, can be done instantaneously. You'd be surprised how long it took them to move that, get up to date on that thing. But I think most of the petitioner's attorneys seem to be up to date on that. We can file motions to dismiss. This is done when, if we set up an evaluation, for whatever reason the petitioner misses our evaluation. We could file a motion to dismiss. This is done very easily. We do it electronically, where it's filed automatically. It'll come up when the court gets a motion filed. They'll list it usually within 30 days or so of the motion filing to move it along. They're not always granted, but it sends a message. It gets the claim moving along. Petitioner's attorney may get a little nervous. They'll get their petitioner's cooperation, and if they don't have their petitioner's cooperation, the claim will be dismissed, period. Again, getting the judges on your side, letting the judges know that you're ready. We've done everything we can. We've sent all the medical records to our adversary and so forth, and the only thing they need to do is get an evaluation done. So we'll push that along.
I mentioned the fact that sometimes we're their diary,
Yeah.
and we do follow up with them and remind them to do their job, which is unfortunate, but we have to do what we have to do. Mark, you were going to talk about, I think our last topic is it takes three to tango.
Well, I think we've talked about that quite a bit during the course of today's proceeding. Again, it takes the three is the petitioner's attorney, us, and the judge, and you want to use all of those individuals to your advantage. Certainly, an open line of communication with petitioner's attorney is good. I try to do that with all my claims. Letting them know we had the petitioner evaluated. We're ready with our report. Send me your report. Send me your settlement demand if there is one. If it's a minor claim, how about we bring the petitioner to court at the next time it's listed? Take a look at this scar to see if we can resolve it, and things like that. Again, having the judge involved in the process will move things along, because if the judge senses that someone's dragging their feet, they'll get involved and push it along. And that's basically, it's a hands-on approach. You want to form good relationships with your judges, letting them know you're doing everything you can to move the claim along. And if there's a problem, it's got to be the other guy and not us that's cooperating.
So get on our side. And something that we do as a firm and as a department is we request authority after a meaningful conference or the demand from petitioner's counsel very promptly. We send out the final settlement orders within 24, 48 hours of the final hearing. Same thing with the request for authority. We're going to send that out promptly within 2 or 3 business days of the hearing, so that you have it as soon as you can get it. We generally request short adjournments. I don't request 3 cycles. We don't request 9 weeks to get authority. We're going to request 1 cycle if we can do it, or 2. And if we request 2 or 6 weeks, we always tell the judge and opposing counsel, if we hear sooner, we will let counsel know, seek authority from the judge or the approval of the judge to bring the case in as a quote-unquote add-on. And we'll settle it 3 weeks later. Because we know that you guys are all about closing cases, moving them quickly through the system. And that is fine with us. That's what we're built for. We cover for each other. If somebody's out, the lists never get adjourned. Somebody else will cover that list. And we try to move and settle them as quickly as we can by affidavit or whatever it takes. So we keep the cases on as short as least as possible. So, again, it takes 3 to tango. But if we're doing our job, you're helping us and backing us up as well. Then the judges put some pressure on petitioner and petitioner's counsel. We can do all that we can to move these cases a little bit more quickly in New Jersey. So the last thing I want to show you is our future schedule. So on May 24th, we have some discussion by Chris Davis and Peter Harrison in our Philadelphia office on VA workers' compensation. And you'll see the future schedule for some additional WG University seminars. And as Mark mentioned, if you do have any Medicare issues or delays, we do have Renee Parada, my partner from our Pittsburgh office. Renee is an expert in Medicare issues. She deals with them and has a pipeline to certain great sources, and she can help you with those delays, which have been quite a problem over the last couple of years. So again, thank you all for your attention, Sorry we're a little bit longer than normal, but New Jersey does take a while. Thanks. Have a great afternoon.
Thank you.